Okay, everybody ready to resume? Yep, thank you. Just a reminder again about phones, please, if you could switch them off or silent. And this Tuesday is not a day for fire alarm tests, I take it? No, Wednesday. Oh, sorry, Wednesday. We're Wednesday today. You're Friday, Council. Okay, thank you. Okay, so if the fire alarm goes off, we must leave the building. Yes, I actually know my way out now. Okay, nothing else before I back on? No? Okay. So you want to know what I think about the agreement, obviously. Yes, well, notice one I'm calling the enforcement, the non-compliance with the condition notice. Which one? You call it notice two. Okay. I might have to vary things in the decision somewhere. So looking at that notice, yeah, it's on the basis that the council has chosen to under-enforce, and that reflects the expediency role that it does have. I don't think I can come to any other view than that it's open to the council to do that, and I can amend the notice without injustice, I think. So, yeah, effectively, it's because the council has chosen to under-enforce. And typically, if I notice under-enforcement, I will always ask the council if they have meant that. And if they have, then essentially it's standard practice to not to question that. But if I had to question it, I can see where you're coming from. Notice two. Sorry, notice two. In my notes is the 2020 hardcore and hard standing on plot 3. So, given the amendments to enforcement notice 1, obviously it seems that very special circumstances can clearly be demonstrated on that. That's the one where I have to grant, but and also council doesn't have to answer this, but it would have been open to the council to withdraw that notice. Did you consider that?
Standing then.
Okay.
Safer for my clients rather than as.
Yeah, well, it's arguable that given the amendments to the first notice, but I can, yep, okay. As I say, it's even the first amendments, obviously, it's clear that very special circumstances would exist. And the changes to notice 3, obviously, they're logically consequential on the changes to notice 1. Again, it's the council's choice to under-enforce, and so I can't see any injustice to any of the parties by making that amendment. Does that beat? I take it, well, according to what you've agreed here, it should result in the withdrawals that you've set out there. Yeah.
You're minded to accept our invitation, so
Well, I've just said that, Jim. Yeah.
Also follow the appeals that would be.
Yeah, no, there's plenty left, don't worry. So, on the procedural side of things, I haven't I'll need a mechanism of some kind to have the appeals withdrawn. Effectively, it needs to be done in writing, because it's framed here as in response to my decision. I suggest that on issuing my decision, I'll get the case teams to invite you to formally withdraw.
I think that probably, I mean, the only reason for achieve that way, sir, is, you know, I mean, I'm sure you wouldn't, but some expect the occasion will be an inquiry, and then something dawns on them afterward that they've perhaps not. So if we'd already withdrawn, you wouldn't be able to sort of reopen the inquiry to deal with something that you felt.
Yeah, that's true.
I'm sure that doesn't arise, but I am just protecting my client's position that suddenly.
Well, things can come from other directions than the inspector as well. So, but anyway, that's the.
What I might suggest is if you put it in writing, inspector to treat it. But he can accept your withdrawal if it's the extent that something substantially similar to the statement of common ground position is to be eventuated otherwise.
Yes, I mean, we've got.
Well, I have it in writing on it's in the signed statement of common ground to that effect. It's just for the purposes of, let's call it, administration. The appeals need to be formally withdrawn by somebody, not by me. And of course, this isn't a formal withdrawal, it's a conditional withdrawal. So I'll probably have to think about it further, but just bear that in mind, that it's a resolution will have to be found to that. It's
just before you come to the decision on the appeals, you were to say that you writing that you had accepted.
I can do a minded to a letter of some kind, I suppose.
Yeah. What then ourselves could respond by saying, in light of your letter, our appeals withdrawn.
Yeah.
See, one of ours is withdrawn because
no, I've got that.
To allow you to.
Yeah.
That's not determining the appeals, that's you just determining reaching a point after the event we've accepted the verbal.
Yeah, well, I mean, I would have accepted the changes in a formal decision anyway.
But what I'm saying is, it's not.
But then it would seem odd if I had to go on and not determine those appeals, because they would still be live at that point.
Well, it's a process.
Yeah.
You could put something in writing afterwards that would suit you, and then.
You understand that sort of thing.
Yeah.
So,
Okay, so if anybody has any better idea by the time we finish today, I appreciate you probably haven't thought about that yet. So.
Minded to
Yeah,
letters seems to work to me.
I've never written one, but I always see it as a Secretary of State thing. But if given that I'm standing in his shoes, I'm sure I can probably do that too. Okay. Have you got an order of?
Well, what we thought we'd do is proceed as planned with the round table, and then Cummings followed by Spooner, followed by.
Yeah.
We'll just call them in order.
The Lions is doing.
John will be.
All right. Okay.
On the round table. So.
Yeah. So who's in the round table? Just me? Okay. Yeah, that's fine. I suppose, well, first of all, on the current situation, really, I suppose, Mr. Jarman, you did the 2018 GTA, which I take it was based on 2017 surveys.
That's correct, yes.
Yeah.
I'm doing as we had the requirements.
Yeah. But it was still based on the 2017 survey.
It was based on the 2020 baseline, then rolled forward to a 2019-2020 to take out the emissions.
Yeah, but there was no new survey work. It was just
there was new survey work for all of the new sites.
Right.
Sites
okay.
Model the population out of
the new sites then, but they're sites that were allowed on appeal.
Were any sites that had been granted permission or in the period, and also there were a number of sites where the 2017 some sites incorrectly.
Right. And so then along came Lisa Smith and
Smith, yes.
Yeah.
That's three dates, yeah.
Oh.
I preempted Lisa Smith, and our assessments assess the needs of all travellers in the same way. The requirement of the PPTS is the standard and
is it?
Well, PPTS hasn't changed.
I know PPTS hasn't changed, but you can't really apply the definition, can you?
But well, essentially, at the time of doing the update, we requirement to split the needs identified. So, if as a result of this,
Okay. Well, so yeah, the Lisa Smith was the well. If you went back to the 2012 definition, you wouldn't be lumping them all together, would you? I mean, I'm not objecting to it, but I'm just.
If you went back to the 2012 definition, essentially the single assessment.
Yeah, that's not how I recall assessments before there was still the concept of people who met the definition and cultural travellers who didn't.
There was no split in pre-2050, because it was assumed that under that broader definition, there's no nomadic lifestyle. Probably all gypsies and travellers who were in 2012, yes, they were non-travellers.
Yeah. So is that the main source now of non-PPTS? How do you deal with the settled community? Because I mean, I know there's quite a lot of non-gypsies and travellers, or people who've never travelled effectively and have no cultural attachment to travel.
First thing we seek to do our house of Wickford status of the household living in based on whether or not they are travellers, travelling show people, or whether they are that community living in apartment sites. Anything is excluded from the DTA, but normally we're in a position where we're also completing and considered as part of the.
So Ms. Lyons, what's happening then with those numbers? So
in terms of where the council is,
yeah.
I'm not so and making. Heading for a draft plan the end of this year. So starting again to look at obviously in applications for all our housing needs, and obviously then Egyptian child question and where it's like where we are at the moment. And obviously it's set out in the onus statement obviously. We have had a number of sites come forward in the last 2 years, and that's set out. So we have got there is an unmet need regarding our landscape life in 2025 pictures, but we have made inroads to say we have another local plan to table 5. It shows the increased number of transits we've had since then. We've gained 29 new. So that hasn't met half. But for a Greenbelt Authority, that has made some. It's right. In a situation where you are in the Greenbelt Authority, we haven't got any policies. The 1998 local plan hasn't got any development control management policies. So at the moment, it's very difficult for all housing needs. Hopefully by the end of next year we'll be at a draft plan stage and start seeing some change in that policy. Make it easier to look at poor housing across the borough.
But you did the consultation. Yeah, I saw the responses, but I couldn't see who was consulted or who was making the responses, because if you mainly Greenbelt and you haven't allocated, you're looking at very special circumstances for criteria-based policies.
At the moment,
yeah.
I mean, we say I'm going to set the end.
Yeah.
But I still think in terms of We're not having enough pass. That's part of the challenge. I can't, because we're so early in that kind of position, I think from our perspective, we will have to treat that carefully how to take that forward. But I think some sort of allocation. Very difficult in green belt policy. The criteria-based policy deal with the needs that we've got. Mixture of paragraph 6.1 to 5.3. We're looking at criteria. I can't say any more than that. Plan is such a early stage in terms of the green belt review isn't completed yet. We can't do that until we haven't gone through all our we've got a strategic housing needs assessment to be completed. The John is just working on the and also then start look at moving forward in terms of PR and how we are straight as well.
So what percentage of the borough is green belt? 63%. So 63%. I was going to say, you see, you've got the rest is already yeah. You don't have any open non-green belt land.
Very little, because obviously it status very little. It's very little brownfield. Most brownfield is mainly around garage court. Again, we're doing a very we're doing a note stone unturned position in terms of looking at all urban. So that was part of the works we undertake. That's the fastest in the not typologies of training.
And Mr. Jarmuth's original GTA, which you brought forward, that was for all of Essex, or this part of Essex?
The 2020 update was just the Basildon.
Yeah, I know that was for Basildon, but the work you were working on.
We're currently, again, it's a little bit hodgepodge. It's initially commissioned as Greater Essex.
Greater Essex, that's what I was trying. Yeah. Right.
But Malden decided they need to opt it out, part of the wider saying they have Essex. So there will be Greater Essex GTA.
And yeah, so my next question is there some degree of cooperation between the Greater Essex councils on travel site provision?
So,
given that if you're saying you can't, well, I think what you're technically saying there is it would be very difficult to meet the full need as set out there.
I think.
All right, okay.
I was involved in a very lengthy local plan examination. We bring up a very similar situation to that. The urban area.
Yeah.
And
they've got a lot of brownfield.
And what was agreed through the examination in travel years ago, agreed that need 200.
Yeah, exceptional circumstances.
Yeah,
so,
sorry, exactly.
Yeah, so
there is a precedent in certain circumstances with the need generated from sites.
You know, I think that we're quite away.
Yeah. Yeah, no, it's
across south, so Essex is split into basically two halves, so you've got South Essex Authority for the seller. So basically, ourselves, Brentwood, they're at South End, Watchford, and that's to some extent Essex. We've as County Council, we've joined as and that will deliver. And that's not obviously it's not a strategic plan making function. We operate as a part of that. We'll be looking at the growth strategy, and that may allow for some across all types of houses. There might be some opportunities. Growth needs to be tracked within those criteria.
Yeah.
That's not down to it's still suffering in terms of the planning and decision.
Going back to most of the recent site provision, most of that's happened through appeals, isn't it?
Yes.
Was that because they were all in the green belt and?
I mean, they're all in the green belt, also they've all occurred. I mean, there's only one of them that was approved. That's the plan. I'm saying South one was just got. And most of the rest of it hasn't occurred. So yeah, they are all within the
So, Mr. Jarman, to what extent are you aware that the current occupiers of Newlands Road are accounted for in your figures?
In the figures in the published assessment.
Yeah.
At the time of the updates, the units are and they were
And do you know anything about the other occupiers?
I do, but I just reality.
Yeah, well, I'm not.
We have spoken to the job. Understanding I've had speaking to my they haven't submitted the
When is the new GTAA going to be published?
Again, this is another difficulty in completing the assessment, essentially. Field work and analysis on a priority basis. The figures to be. My understanding is
Yeah.
We're holding everything on. We do it for the independent project domain,
Yeah.
so I have to do that.
That's
So you
good.
tell what in
Do you know when? Yeah.
to appointment, and we've got a lot of work is quite advanced, which is like.
Yeah. Do you have any idea when it's going to be out?
So, I mean,
Yeah.
we've had various times from, well, the end of the financial year, that's what we've done. I think it depends on the election.
Okay.
You know, national elections are so that it's worse.
But Mr. John, so you have had field work back out on that side. When was that? Just out of interest. So just going back to the need figures then for so many documents. Figures 1 and 2 of the GTA update, which set out the meet planning definition undetermined and do not meet.
Figure two.
Figure 2, yeah.
Has been wrongly translated.
Okay.
Figure 1 is the correct figure. There was an update, and I think figure 2 was the. That's room.
Okay.
Figure 2. Figure 1, the 68 up to 58. Outruns.
So if I was to draw a line through figure 2,
Line through figure 2, and
it's just the numbers at the bottom, but
instead refer to figure 10, which is the correct figure 2.
all right, okay. So if I went, yeah, so anyway, if you look at the total here, without flicking over to figure 10, which I'd have to look for, so that only deals with people who meet the planning definition. And you're saying now that essentially all would go into that category.
No, this
Okay.
is where I still think there's a need for some further clarification.
Yeah, clarification by the courts, by the government.
By somebody. We all know about this. Yes.
Yeah.
But the government subsequently consulted on his NPP Act. So you still have a requirement of 51 sets and address the need for non-PPTS travelers, and you still have a requirement under the PPTS. They're still there. So it's council to seek to meet.
Yeah.
But currently through what combines the plan policy, I would hope that need in them. Very much bring out.
So looking then to, so you gained 25 new pitches. And have you made inroads into the need? Well, it seems to me that the 43 here, by comparison, let's say, even though it's wrong, but there'll be a breakdown over. It seems to be front loaded. In other words, there's a very high need that needs to be met at the moment, and after that, if that's met, then you're into a more sustainable program.
Figure two, just it's only the total figure that's.
Yeah.
It should just be 68 instead of 50. The constituent figures for the year periods are correct.
Yeah. Okay.
Shows you what you gained, it shows you what the need is. Basically, we accept the
Yeah.
You know, we will deal with it through the criteria party, which we will do suggest like yes, and that's rather than the silent patients, but I think going forward we're going to have to look at whether we can find sites as it's specified. It's John already is using it. We have had new sites in the D-Line already. We are. But in the meantime, we will have to do based on local circumstances.
So in terms then of well, we accept it, or you're accepting it essentially. There's a pretty substantial unmet need in the district. Yeah. Yeah. I'm not housing appeal decisions, you mean, is it?
We've had planning groups on
general housing. Yeah, that's what I mean. Okay.
We are general lack of so where planning system is.
And just considering then the possibilities of temporary permissions, is there anything in any event on the horizon that could be pointed to? There's no allocations, no adoption of local plan, but in
the LPS shows that we will be at draft plan with regulation 80 at the end of next year.
Yeah, but you were like 2028 or something by adoption, was it?
Based on
7, right?
That's based on.
Yeah. So.
I mean, that may even be said about the end of the year. We can't get anything moving until we've got that. That does significantly impact our. Not going to be evidence in green dot reviews.
So your local development scheme is the numbers in that. Were they based on having an updated or well a new NPPF in place at a certain point?
We adopted that before.
Yeah.
Just as the everyone thought we have the new. The bill would be It's been so many last year. We work, but we do that quite closely. They do that to on question. Our progress now is slow.
Yes, I just wonder, is the local development scheme already out of? It's already behind.
We're slightly.
Oh, okay.
We're a month or two out. We're on time for the. Might be out. It's the regulation 18 draft be delayed. That is going to delay that. Delay that. Yeah. But I think it will only be again. I think water. We need a plan desperately, so our aims are to put that draft plan.
You're hoping essentially if the NPPF is clarified soon, you'll only be 3 months behind. Is that what you mean? Yeah. Okay.
If it comes too quickly, we'll be on top of time. If it's pushed back next year, then all our choices. I think the expectation of the generally push back.
But without allocating, what difference will the new plan make? I think you've got a satisfactory criteria based.
Yeah, so because just obviously just over the consultation
Yep.
period, and we're now starting to look at that. We're looking at that's our next step. We're looking at capacity studies and start to bring forward sites that will have some potential for housing, right? And I use housing as a general topic, not as a typology of changing. And I think, we may have to take an approach like maybe to isolate some land. In the previous withdrawal plan, there were a number of sites came forward were specifically from occupation. So I haven't looked at it in detail. I'll read out yet to see whether we've got the planning sites. Generally, local authorities trying to put out and I think we're not quite. I can't comment on it.
So optimism. Yeah. Okay. I'm just.
And I think that the ongoing 5-year review of all plans, I think, is an important step for plan making. Allow you to review that position and also constantly updating your space to
And just going back then to what Mr. Jarman was saying about not him no longer seeing any significant difference between PPTS and non-PPTS, other than the fact that they fall into different policy documents, effectively. Yeah. So. Yeah.
Just think through technically separate policy mechanisms that currently and are continuing to.
And that's the next.
I think the difference is if you are a traveller, if you definition when you travel for work, your requirements are tend to be from a larger yard. If you go to work, needs are on those individuals, and how we then deliver that housing types. I think that in terms of the challenges and what adds weight to the jiggy challenge is about deal with women at special to warrant changes in how we do those units. We'll look at the figures that come forward from do an assessment.
You'll have, well, if you were to look to meet them all to the same policies, you'd have quite a lot to find. Well, I know obviously you've got to find them either way, but
Local authorities where you've got a high population of what we're happening. And when we agree about authority, so that
so looking at current availability, what's the situation with vacant sites in the? Okay.
So one thing that happens, so we haven't received the actual completed. One thing consistent with previous are relatively high.
Yep. I think the last time I saw you was in Runnymede, which that was their plan, wasn't it?
I've been looking. I recognise the place. I recognise the name.
Yeah.
That was it was fun, wasn't it?
Yeah, yeah.
Yeah, and they had the orchards. It's common that Basildon has a very high travelling caravan count, but a relatively lower fixing traveller occupation rate.
Yeah. I did think the census seemed a bit odd that the numbers didn't seem to match the
census in 2021.
But then I was going to say census. A lot of people don't necessarily.
But also, the government introduced the ethnicity category in 2020. Right, it's possible that a proportion. I know for a fact as well, but it's accepted in 1901 that there was and I know for a fact that the ONS did considerable work to anywhere with my period in the work for the ONS during the probably visited sites in essence.
Yeah.
So first-hand experience meant that the government gone to mainly not into a lifestyle. Social housing. Other people, there's a large showroom charge. Called travel caravans then of which 8 are by non-travellers. There's a
Well, I suppose the closer you are to London, the higher costs are. Yeah, Alex, I think I've got a reasonable picture. I'm sure Mr. Green is itching to say something, but he can't. No.
I've been listening carefully, and actually, Alan's been quite fair. It's quite interesting. But we're not in a situation of that. I'm being 95% of it. But I have that invited. All right, I've got it on this occasion.
Just committed to memory again. And just finally, the last, you're obviously not the enforcer. It may be Mr. Cummings who can answer that. But do you have? I gather you think you have a problem with non-gypsy travellers occupying gypsy traveller sites.
Spot but our homes are very close together. We just like to do it. And we'll be careful because you then shift people into the homeless world. That adds further funds to the council. We've done a lot of field work for it.
So you've done the field work to identify.
Yeah, to identify the sites.
Okay. So is that a process of expediency?
Yeah. A lot of it is around actually a lot of it is also around the fact that the parents are very close together and it's actually general.
Yeah.
So it's not just picking up.
Oh, so you're looking at breach of site license conditions.
Well, they've got claims you can't license them, so the point is that we're trying to, they're not technically safe. It's one of our issues. But also, they are taking a valuable land, which is actually.
One thing that my field work has sort of found is if I was that it'd be relatively easy to identify caravans if some of the travellers and were coming in what looked to the air to be stable box. So we've actually identified
And have you factored that into your your future supply, if you like? Yeah.
John is just completed for us, and
right.
I mean, I think that we need to be, and that's why it's not evidence check. If you see it, we need to collate it alongside that the evidence that we've got. Possibly then to play into that next step.
it needs to be put together.
Yeah. And I think then that feeds into the local plan.
Exactly, yes.
Okay.
Yeah. Benefits where we got yesterday.
Do you create two? That's what I couldn't quite understand.
Well,
two pictures.
Where's the second new one?
Two.
Oh, right, okay. Yeah, I couldn't quite understand that from that. Okay, I'm content that, well, I can't really extract any more information from you, I don't think, because we're going to.
Thank you. So,
Yeah.
would we move straight into Mr. Cummings?
Yeah, yeah. Cummings, do you have to swear or affirm? Okay.
Cummings, you are employed by Basildon Borough Council. You're the team leader for planning and enforcement, a role you've been in since 2018. Qualification in planning and enforcement. You're retired, so having served in Essex Police for 30 years and have extensive enforcement in a number of operational roles and achieving the rank of Chief Inspector. That's correct. We have your proof of evidence and we've got an introduction. The scope of your evidence is set out at section 4, and which you explain it should be read in the context of the other evidence for the council, and then you set out and then summarise the enforcement notices and the case for the council against the first enforcement notice at section 10, and summarise the council's position under each of the grounds. And then the second enforcement notice, as you've called it, I'm not sure if it's consistent with the numbering, but it's clear what it refers to. It's section 11, and then section 12, the third enforcement notice. So if you're content, we'll take it all as read. Nobody need to read a summary in this context. Mr. Cummings, I think I'll hand you over to the inspector who may have some further questions. Is there anything you wanted to add before we do that in light of the statement of common ground position?
Thank you.
Given where we are now, what I'm mainly concerned about is the extent of knowledge of the personal circumstances of the current occupiers that are not affected by the amendments we've agreed. So, just I assume that when you're investigating a site, you do the questionnaire, the welfare questionnaire approach.
Indeed, so we do, and on this site, we've done that on a number of occasions, repeatedly over a long period of time, and engaged with agents trying to collate information about personal circumstances, and indeed on site, going literally door to door. And recently, I think in August, hand delivering letters where people to plots where people were not present, and engaging with everybody we possibly could. It's probably fair to say it's hit and miss. There are very limited individuals that were willing to talk frankly, and most were quite evasive. But all efforts have been made repeatedly over a long period of time.
We got the statements yesterday from Stokes, whom you had recorded on plot 13 before. So I just, first of all, you say you've been there a number of times.
Yes.
That's since the first notice was issued, or?
Prior to that even. for a long period of time. Since 2018, I've been familiar with the site.
2018 is when plot 3 came about. Yeah, so that's kind of when you've started visiting. Have listen to the wider side. Has there been a lot of occupancy changes?
Yes.
So there's quite a lot of unknowns here. So this is August 23. Where do we stand today as far as you're concerned? Are we very far away from that?
No, I would say the information gained in August is probably still, very relevant and accurate as far as I can tell. There is, I would believe that a number of these individual plots possibly have changed hands in terms of ownership, not registered necessarily formally with the land registry, but there is the impression that I've gained from visiting the site and talking to individuals that there's a real mixture. It's not a coherent site in the pictures that we're talking about, 1 to 14. At least there's even one pitch, I think that's pitch 12, which I believe is owned by a settled resident from Romford who rented it out. Others possibly are owned by what presents G&T individuals. So it's quite a discordant situation, as I'm sure you'll see. So when you do the site visit. None of the pictures or the occupants, more importantly, seem to relate to each other in terms of family links or anything like that, which is quite uncommon in my experience of attending G&T sites where families quite often predominate and it's cohesive and stable. In this situation, it's far from that. And has led to many of the problems that have been very clearly sort of expressed by the residents of the Chase, in my view.
But you visited in August 23, and got Mary Taylor's statement here from who claims to have moved on in October 22 onto 9A and 9B. I'm not sure if she was talking on both sides, but her partners claim to own both sides. But when you visited, you couldn't. You've got unknown down in both cases. They were occupied, I think.
So when we visited and looked at 9A and B, we found a lady on plot 9A who identified herself as a cleaner, wasn't the occupier. She was unforthcoming, wouldn't communicate any details to us at all. So we left a package, as we did with all of the other plots, a letter containing the human rights questionnaire, as you've already referred to, and a covering letter asking for engagement and to contact the council to make us aware of any personal circumstances or needs that we could take into account. We've not received anything directly from that plot.
Have you received anything in response to that visit from any plots?
Yes, we had a response from plot 1. I think that was the only one. That was the only one we had. Plot 1 is, as you know, the paddock.
Yeah. Well, on plot 6, you've got Mary and 3 young children. You know anything about whether she's a traveller or not?
No, nothing more than that. And as I say, we haven't had a written response.
Okay.
Despite the invitation. That was the fragments of information of what we could glean from the site visit. I think speaking to children that were on that plot.
Any records of school children from the site? Are people enrolled in schools from that site?
Some of them are. I think a local school, Clays Hill Primary School, is commonly well experienced of receiving gypsy and traveller children. We made an effort to make contact with the Essex County Traveller Unit, who have good outreach links, and we were to confirm some details, I believe, in relation to that plot about attending school.
That plot?
I believe so. I think I would have to check my records.
You have records of the contact with Essex County Council Travelling?
Yes.
Yeah.
I don't have them at hand at the moment.
Here's something.
They'll be easy as a table.
Okay, if you can. And so you've been in contact with Essex County Council Traveller Unit about the whole site?
I'm
just
not the whole site, but well, I think yes. From memory, that inquiry, we asked what details they held in relation to the whole site, and we have a response. And very limited, though.
Yeah, the kind of, well, I'm sure you'll tell me soon, but the kind of details that they would have available is
school attendance, any records of anyone from Newlands Road of school age attending.
Do you have any clear idea of what's the formation of the hard standing on the site? I've heard a lot of tipper trucks coming in with construction waste. Is that something you've looked at?
Yes, I mean, over a long period of time since 2018, this site has gone through various sort of development changes in a sort of incrementally to what you see now, as the aerial images will illustrate. Probably this image in front of you, you can see the grey mass of hard standing that has been largely formed over a majority of the site. We have experienced, I think it's 3 large fires on the site where either caravans or trailers have been burnt. They contribute to, quite a poor appearance on the site, and waste materials. There's a trailer or a vehicle body, a lorry that you can see at the north of the image, top of the image, that looks like an abandoned and dumped vehicle. So over time, there has been various bits of waste, fires, and all of these have impacted detrimentally on the amenity for nearby residents.
That's saying, well, I happen to have the appendices here to hand. Anyway, I take it, yes.
Not the appendices.
Yeah. I take it you've got no knowledge of the source of hardcore forming the surfaces on the site.
The source, as in the providers?
Yeah.
No.
So it's okay. Question, what I'd like to know more about is what the Essex County Council responses show. I think that's probably the height of your knowledge of what children are on the site and what their needs are. You personally have been visiting the site, I take it?
I have.
Yes.
That's what we have to assist on the county councils.
All right. Okay. Yeah, that's fine. I don't have anything further, Mr. Cummins.
Okay. Thank you.
Thank you. Did you? I take it you didn't want re-examination of any kind? No. Yeah. Bruno, do you want to swear or affirm?
May I affirm, please?
Okay. Just repeat after me. I say Silke. Is it?
Silke.
Silke Gruner.
I, Silke Gruner,
Solemnly, sincerely, and truly
do solemnly, sincerely
declare and affirm
declare
that the evidence I shall give
that the evidence I shall give
shall be true,
shall be the
the whole
truth,
truth.
the whole truth.
Schooner, we have your proof of evidence. You are a landscape associate for Place Services, and I understand that's the trading arm of Essex County Council.
That's correct.
And you're a chartered member of the Landscape Institute with 17 years experience in undertaking landscape and visual assessments and master planning and urban design. You're director of ICNE projects.
That's correct.
Thank you. And you've explained you set it out in accordance with the Code of Standards of the Landscape Institute and your professional duties. We have at the outset of your evidence a summary and conclusions section. Do you have that in front of you?
I do, yes.
And you explain at 1.5, limited development would have been visible previously. And then in your summary, 1.6, views of the open land no longer available. You talk about 1.7, a summary of the appeal site having been one of the green fingers of open land, reflecting the historic character of, and the network of open land plays an important role in reflecting and respecting historic character, maintaining a clear rural separation, and maintaining the countryside rural setting of both settlements. And then can I just ask you to read from 1.12 through to 1.15, then I'll hand you to the inspector, please.
Of course. The unpermitted development at the appeal site results in substantial harm to the landscape character of the appeal site. It results in the loss of part of the open character of the study area, which is in itself a harmful effect. In addition, the design and layout of the development does not integrate with or conserve the character of the receiving landscape within which the appeal site is located. The unpermitted development adversely affects the value and function of the landscape between Wickford and Basildon, and that around the Plotlands neighbourhoods. This results in an adverse effect on the landscape character of the study area due to the harmful impact of the unpermitted development on this landscape. Furthermore, does not comply with guidance or planning policy. The unpermitted development of the appeal site constitutes a sprawl and encroaches into the countryside, therefore results in harm to purposes 1 and 3 of the Greenbelt. The unpermitted development adversely affects the separation between Wickford and Basildon and harms that purpose of the Greenbelt. While the unpermitted development does not contribute to nor harm purpose 4, it does not accord with purpose 5 as it is greenfield development. Considering the scale of the unpermitted development alongside the fragility of the Greenbelt in this area, this development results in material harm to 4 of the 5 functions of the Greenbelt. I find that the appeal site significantly harms the openness of the Greenbelt due to the spatial and visual harms, as well as due to an increase in activity. Considering the importance of the remaining open space within the landscape between Wickford and Basildon, the development at the appeal site and a consequent reduction of open space is harmful to the character of the landscape of the study area, and the unpermitted development of the appeal site should not be allowed to remain.
Thank you very much. If we take the rest as read, please, sir, and if you have any further questions for Spoon.
Thank you. So first, the purpose of preventing sprawl of large built-up areas. So, how does this particular site assist in that? What I notice you said here the built-up areas are, well, Wickford and Basildon. Is that those are the built-up areas?
Those are the 2 key built-up areas. Yeah. Between them, we have the Plotlands and we have some development. But that part of the Greenbelt specifically stops those two merging, and it stops sprawl. So it contains those two settlements within their boundaries, really. And the purpose of that is, one, to protect the countryside, or to protect its openness, but part of that is to prevent the merging. And that is also why you want to contain sprawl.
Yeah, so the towns merging and the large built-up areas are two separate aspects.
Yes.
Of the purpose.
It's one of the greenbelt purposes. That is what policy tells us, is to prevent sprawl. So anything that we're building in the green belt in the vicinity of a settlement is extending the site of that settlement. And if it's unplanned, then that is sprawl. Yeah,
and that's how I just wonder how I can see the towns merging. The sprawl essentially would have to be on the margin or edge of a built-up area.
And it is because
a large built-up area.
Okay, so we can take Wickford as a large built-up area. It's a town. When we consider the existing development within that green belt, which it is quite dense and is therefore touching and is probably already seen as sprawl. Now, of course, lots of that development was there before greenbelt policy came into force or came into being. So it isn't a straightforward, this is adjacent to the settlement, it's sprawling. Mm-hmm. This is sort of adjacent to a bit of land that to development which is already adjacent to the settlement. So it's almost an addition of existing sprawl. That's how I would describe that development within that greenbelt parcel.
It's not just you. It's you've referred to inspectors who've used the same term, but the fragility is that the feature then that you're talking about, the fragility of that part of the greenbelt.
That is unique, but it's got a specific character, that part of the greenbelt, because of the plotlands that were there before and the greenbelt washing over it afterwards. It is a part of the greenbelt that does have quite a lot of development in it already, and especially in terms of its function as a separating function between two settlements. The more development you put on it, the less it functions in terms of a clear separation. And and that is why it is, it is already quite fragile in that it is clinging on to its function.
All right, so that's what I was going to. So you're saying it's just about carrying out.
It's just about carrying out that function, but it's yeah. And I think one of the studies specifically says, just because it doesn't contribute to the greenbelt purposes doesn't mean that it's not important. Yes. So it's actually even more important because it has so much development within it already.
You talked about encroachment. I know it looked like countryside, but it was it did have planning permission as a caravan site.
It did have planning permission as a caravan site, although the amount of built form or caravans on it was limited.
So if you have a caravan site in the countryside, do you consider that to be countryside? Is countryside a designation, or in terms of MPPF?
No, I don't think countryside is. No, I don't think it is designated.
But sometimes it's in local plans.
It's in local plans.
It tells you what countryside.
I'm not sure if the MPPF actually does say what countryside is. I think we can assume it's its English meaning, or I assume it's its English meaning. And
you'll know it when you see it, kind of thing, is it that?
Well, we sit and argue about that for many weeks, but let's say it's not a town or a village. It's clearly not a settlement, I think is probably what the countryside is. Now, again, yes, it would have been, the remainder of the field would have been left as a field. It appears to have been used as a paddock before. And again, a paddock is a use that we associate with countryside. So the appearance of at least a large part of the site would have been perceived as countryside with some development on it.
Yeah, you would think they would have defined that particular purpose by now. Okay.
It's fun to argue about, isn't it?
So the plotland study you referred to,
Yes.
what's the purpose of that, to try and safeguard plotlands or find developable sites?
It was to find developable sites
Yes.
within plotlands. So yes, looking at these areas where you already have development and you already have some infrastructure in terms of roads and electricity at least, and saying where you could accommodate additional houses without losing the character of the countryside and also the plotlands themselves.
So did you have any criteria? I mean, you say you didn't identify this site as developable, but I mean, for some purposes, it was already developed. So was it considered? Are you aware?
If it was considered,
Are you aware whether or not it was
within the plotlands?
plot?
Within the plotland study, it was considered as, you know, whether you could develop. It formed part of the study area within which they then drew a boundary and some additional pink line areas where development could take place. So it was considered as part of that.
So you're aware of the changes that the amendments to the notice and
Yes.
the outcome of that. How does that affect your view of the site overall and its functioning and its role?
There'll be less landscape harm, less visual and character harm. There will be less of an
Less
impact
compared to
what was this, what is
okay.
currently on site.
Yeah.
Let's put it that way, and also to what I had assessed within my LVIA. It's the same in terms of greenbelt. The type of development which is proposed to remain is a lot more similar in character to what is there. It's a lot more contained. It does leave a lot more open areas or undeveloped areas. So in terms of the greenbelt purposes,
so just go back. So when you say more similar to what's there, is that what you mean? What's
in the
surrounding
vicinity?
The site?
So we have chalet bungalows. Yeah. We do have some caravans, both static and I guess static caravans within the wider surroundings. But the plots that we are looking at are more characteristic of permanent plots. I would say they have
the plots we're looking at
1 and 3.
Yeah,
1 and 3. They're more sort of permanent plots that have a house with a garden and you know, some space, personal space. Whereas the other plots are very much the hard standing with a building. There are some exceptions to that as well, but if we're looking in terms of character of the wider area, a building of sorts plus an outbuilding of sorts is not uncharacteristic. And of course we look at the density as well. So if we consider the density of the surrounding development, the plot sizes, and all how those things compare to plot 1 and 3, there are many more similarities than if we compare that to the whole site, and then definitely the remainder of the plots. That doesn't mean they don't harm the greenbelt. It is just to a lesser extent than what's currently there.
And the visual dimension of Greenbelt, is that as felt from the chase primarily?
The visual effects.
Yeah.
There is some from the chase, there is some from the main road to the north as well. Especially there's some gaps between the existing built form there. And through those gaps, you can actually start to experience the countryside a bit. Forms a bit of a setting to Wickford. It maintains that idea that Wickford doesn't just extend into Basildon. So the visual effects, yes, they are limited from public vantage points, and it's more a perception of built development than a actual visual harm issue.
I'm just struggling with let's say the land orientated. It's north-south, isn't it? Orientation. So if I'm assuming that plots 1 and 3 remain.
Yes. Yes, there is.
Greenbelt issue aside, Greenbelt openness aside, so you've got plots 2, 4, 5, and 14. All at the same kind of distances from where the receptors would be. That's either to the chase or up to
yes,
the main road.
It's about the perception of the development. So if you move by and it's a glimpsed view that you're seeing through trees and stuff, you will see a bit of development here and there. The intensification of the development, the density of the development is what causes the greater harm. So it is not that you can see development, but that something looks really developed, or a settlement, or there's something big going on there, as opposed to there are 2 properties.
Yep, I think it's covered all of the issues I wanted to raise. And nothing to come back on for yourself, no? Good.
Thank you,
Thank you very much, Ms. Brunner.
They are called Katie Ellis.
That's swear or affirm? Don't mind. Just repeat after me. Is I, Katie Ellis? And do solemnly, sincerely, and truly declare and affirm that the evidence I shall give truth, the whole truth, and nothing but the truth.
Dennis, we have a proof of evidence and an update from you as well, don't we? And you set out in your proof, your name is Katie Ellis, and you are the principal planner at Basildon Borough Council.
That's correct.
You have a BA Honours degree in Urban and Environmental Planning, and 2 postgraduate degrees, one in Town Planning and the other in Urban Design.
Yeah, that's correct.
And you've 10 years professional experience in development management of various councils in Essex, determining large and small scale developments, residential and commercial schemes in the urban area and the green belt.
Yeah, that's correct.
You tell us you're familiar with the site, and then you set out in your evidence the scope of your evidence. And then we're going to take most of your evidence as read. I'm just going to start with one question for you, which arose from Mr. Cummings' evidence about the children on site. I understand you've been in contact with the ECTU. Can you explain what that is and what contact you've had with them?
Yeah, so we made contact with them regarding any children on the site and what information they had. They did confirm that plot 10, which was occupied by Mrs. Connors, we believe that she's no longer on site.
So when was this your contact with them?
On last Friday, so I can't remember the date. Last Friday we contacted the ETCU. They confirmed that there were children on site, 4 actually, that attended local schools. But as I said, we don't believe them to be on site following site visits that we've attended at the site. One more recently was August, and we did attend the site last Friday as well, actually. And the site, or that particular plot, doesn't seem occupied at the moment.
That was plot 10, was it?
Plot 10, yeah.
So just to understand what you're saying, there's 4 children registered within local schools who have an address at the Newlands site.
Yeah.
And those were the children who you had previously identified as being on plot 10.
Yeah.
But in your latest assessment, they didn't seem to be there any longer.
That's correct.
But so far as the ECTU records go,
They've still got them on their records as being on site.
And that was, did you say you were at the site last Friday?
Yeah, we did attend the site last Friday.
And plot 10 was vacant?
It looked vacant, yes.
Just looking at August, it had a mobile home.
Yeah, so the mobile home and the outbuilding is still present on site, but it doesn't look like as though the site is occupied.
Okay. That's the Friday visit. At the previous visit, was the August one the previous one?
Yeah, so previous to that, myself and 2 colleagues of mine attended the site in August this year. We did at the time post a letter with human rights questionnaire and homelessness letter to all the plots. We did speak to some occupiers of the site that were there. We are aware that there are other children on the site. Plot 1 in particular, Miss Wilkerson had replied to her human rights questionnaire and identified 4 children of her own. That one of them seeking education from a local school, 2 of her children seeking education at home, and 1 being of an age that doesn't attend school at the moment. I'm aware that plot 3 have 2 children, one of which is being homeschooled, and we did meet 3 children on plot 6, but we were unable to obtain information regarding their circumstances. Other than that, I'm not aware of any other children on the site.
You didn't see anybody in plot 9, obviously. That's what
Plot 9, no, we did meet a cleaner, or she presented herself as a cleaner, but yeah, no,
Mr. Goodman, was that all you wanted to bring?
Sorry, that was all
Yeah.
I wanted to ask.
Okay.
In addition, just to bring that point in. So if I can hand to you on then.
Yeah, fine.
Thank you.
Have you had any thoughts about Mr. Green's argument about inappropriate development, with regards to notice 1?
With regards to the entirety of the site as it stands at the moment, we do consider the site to be inappropriate development in accordance with the NPPF, yes.
His argument being that breach of condition is not development.
Yeah, I did note that, but however, we have a different opinion on that matter, and we do consider the site to be inappropriate development. Obviously, I'm aware that we have served breach of condition notices, but and I'm aware of Mr. Green's argument as well, what he's put forward. But we don't share that opinion or that view.
So you're saying you thought it was both breach of condition and a material change of use? Is that the view you formed?
I mean, we've taken a similar approach to the planning inspector back in 2010. I mean, I wasn't saying it was a material consideration, change of use, sorry. But we do consider it to be inappropriate development. But we haven't specifically said that it was a material change of use of the site in the proof that has been given to you.
I don't really want to act as an advocate, so I won't. I'm tempted. I don't suppose you have the NPPF, current NPPF there?
Not in front of me.
No.
No.
Has anyone got one handy?
I can get my.
Well, yeah.
Yeah, so I have got it on my laptop. If you'd like to get my laptop, it is open on my laptop.
Yeah. I'm looking at paragraph 148.
148. When considering the plan applications, we look at that one, aren't we?
Yeah.
Yep.
So there's no doubt that there's harm due to loss of openness, possibly encroachment, possibly other purposes.
Yeah.
So if Mr. Green was right that it wasn't inappropriate development because it's not development, would it still need to leap the very special circumstances hurdle?
I feel as though it would, yes, considering what they're considering the occupants and what they're applying for on the site. I do feel like that test would need to be met.
But it's only set out at 147. Well, it's defined. The definitional harm is defined at 147. What I'm trying to say is, clearly we've been told to give substantial weight.
Yeah.
To the green belt harm.
Yeah.
Then it tells you what happens. If Mr. Green is right, and he is right that it isn't development unless it's a material change of use,
Mm.
because that's refers back to the
Yeah, I mean,
yeah. So
If it helps, like, this might be more of a matter for legal submission,
Okay.
which I can address when I close. I mean, this is
Yeah,
it's
well,
a
it's-
hard test on legal questions that.
Yeah. It's
Um,
sometimes these questions have to be asked, otherwise you won't address them in your submissions. So perhaps you were going to do it anyway.
I'm going to address it in submissions, but
Yeah, great.
I'm just explaining that it's quite a hard legal set of questions that
Yeah.
perhaps more appropriate for submission than for evidence if you're content with that.
Yeah, no, I don't want to cross-examine particularly. So the Essex Coast Rams, I'll say that there are they renamed AONBs yesterday, I think, or the day before. These are now called habitat sites. I can't remember. There's a new term. Anyway, what used to be called European sites.
Yeah.
So we've got that issue.
Mhm.
And I think, Mr. Greenland, you've already resolved it you've done the fee for plot 3.
That's right.
Yeah,
Plot
yeah.
3 is being paid for,
Yeah,
although it's
plot
2
1
units,
wasn't
it's
liable.
two-
So, yeah.
2 mobile homes.
yeah, fine. But because you've got a scheme in place,
Mhm.
has anybody conditioned has the council ever conditioned a planning permission?
For RAMs, no. We
No.
always seek unilateral undertakings for RAMs mitigation. As Ms Green said, plot 3 have paid their fee,
Yeah.
because obviously for every additional dwelling that's on site. We haven't conditioned here at Basildon.
Yeah.
We generally enter into unilateral undertakings. Or, yeah.
I thought you had a scheme that can simply be paid into rather than entering into an
Yeah,
application.
The money does go into a scheme that is dealt with at Essex County Council.
Yeah.
But yeah, we collect the money here via unilateral undertaking.
You do take this up, okay.
Yeah, but so the money is transferred then to Essex.
Yeah. Is that how you, I had assumed it was a standard payment into a scheme rather than entering into an obligation. So different councils have different approaches. It's the last time I've seen it into a scheme, it's essentially it's paid into the scheme in advance of the permission, and then
Yeah,
you get it back after a certain
I've
period.
seen that as well myself. Yeah, I know what you're talking
Okay.
about.
So you've got a different one, and
Yeah.
it's through an obligation, and I won't have an obligation in front of me, obviously.
No.
Okay. I was trying to, because obviously I can't. Well, somebody else, possibly Mr. Goodman, will tell me whether or not I can, if there's a way around that. It's the issue is that I know sometimes there have been conditions requiring people to enter into schemes, and never been that clear whether it's a lawful thing to do. You've alleged, well, you obviously want to give some weight to the intentional unauthorized development. Is that correct?
Yes, correct.
did you mention that in the enforcement notices? I could find it. It's probably something I have to think about anyway. Another topic that keeps cropping up is the effect on the amenity of neighbours.
Mhm.
Is that something that you find to be contrary to policy? Is there an effect that has policy implications?
The site is as it stands, as existing. Yes, there are a lot of, well, there's a few generators and stuff that I know that is impacting neighbours in terms of noise. I suppose a lot of it is noise nuisance, that could be dealt with another way. But obviously, I know yesterday they did raise concerns about barking dogs, generators, light pollution. So all those things that we take into consideration. So that does have an impact on surrounding neighbour properties, especially those that are on the chase.
So when you were issuing the notice, that wasn't a concern?
Sorry, I'm not.
All right. So
yeah, I don't know. I'm not an enforcement officer. So
okay.
Yeah.
Okay. The planners not get involved in notices they're issued?
No.
You need more integration. So had you been preparing the notice, would you have?
Had I been preparing notice, I would have maybe given consideration to neighbours. Yes.
You've had complaints, obviously, for
we've had
quite a while before you issued the notice.
I don't know if we had received complaints prior to issuing notice, but I know we have had complaints via our enforcement team since the notices have been issued. They have attended the site, and that's with regard to sort of foul waste, noise and light pollution. So I know that there has been attendance from our environmental health team. So that would have been a consideration if I had issued the notice.
Yeah, I think Mr. Andrews claimed, he was here yesterday, he claimed to have been complaining since
quite some time.
2017, I think.
Yeah.
When he could, although not necessarily about noise and the amenity aspect.
Yeah.
Fair enough. You think quite a lot of that has occurred since the notice was issued?
I believe, well, I would say Mr. Andrews did give evidence, and his statement yesterday that he'd been complaining since 2017. I know you just mentioned the amenity and obviously their visual amenity from their properties. Sorry, what was your question again?
I was just wondering whether or not you thought that the amenity issues, the harm to amenity, was something that had largely arisen.
I think largely arisen since we've served the notice, and obviously the sort of the extension of the site as such, sort of I suppose what become more notable to them is the pitches or the plots sort of nearer to their boundary of the place. So
Local character is one of your
Yeah, one
domains.
of our considerations is local character. I know Miss Green, you did
Yeah.
deal with that in detail in her brief, and I do agree with the evidence that she's given.
I was looking at the wider aspects of local character, with the non-landscape.
Yeah, so
aspect.
yeah, so
Yeah.
with the non-landscape aspect, obviously the layout of the site, the character of the site is in contrary to what is in the surrounding wider area.
It's very mixed around there. It seems to
It
me.
is mixed along.
I'm only judging from aerial photographs.
Yeah, I say along Newlands Road is predominantly sort of residential bungalows. You have got a bit of backland development there. You have got sort of an industrial character as well in the nearby vicinity, and obviously the Chase is predominantly residential. It is a mix. I mean, what the actual layout of the site that we're looking at now is contrary to sort of the linear development along the Chase and Newlands. So in terms of its layout, it doesn't, it's in contrary to that basically.
The layout isn't contrary.
Is in contrary.
Is
yeah.
Right. And why is that?
Well, the layout of the site, obviously, they're sort of back-to-back developments. They're not linear, such as Newlands Road and the Chase are. You've sort of got the primary road that goes in sort of in a sort of an S shape. You've got back-to-back plots. It does look sort of quite compact in comparison to the surrounding area.
So when you're doing your balancing then,
Mm-hmm.
and considering personal circumstances, have you reconsidered that after the amendments we considered yesterday?
I have reconsidered it, yes. So subject to the amendments of yesterday, I mean, at the time of writing my proof, I wasn't aware of their personal circumstances. However, during the appeal process, we've had further information come forward. And after the amendments that were put to the agents yesterday and the appellants, I do consider the personal circumstances of plot 1 and plot 3, children in particular,
Yeah.
and their lifestyle that they present to us could outweigh the harm that's been identified previously by the council or by myself.
And what about the rest?
In comparison to the rest, I mean, the rest of the site is quite transient. You know, who was initially on site, the occupiers there have now changed since then. As I said, in August we attended the site, and it appears that the previous appellants are no longer on site from the information that we gathered. I mean, they haven't sort of apart from plot 13, we've not had anyone come forward at this inquiry with further information on their personal circumstances. So I do feel, other than plot 1 and 3, there aren't any special circumstances that could be taken into consideration.
So the effort you've put into establishing personal circumstances, is that more or less, or is that typically what you do?
That is typically what we do, yeah. I mean, during and with any gypsy and travel application, we'll write to the agent asking for further information on the status of the occupiers, if there are any children on site, how they live their lifestyle. That is standard procedure from the council. I mean, this has led to an appeal, and we have been outside trying to gather as much information on the ground as possible, and that is standard procedure from us, yes.
So because there's been an appeal, you've put extra effort into.
not, I wouldn't say extra effort, it's the same amount of effort, even if it was a planning application, we'd still carry out site visit, and we'd still try and speak and gather as much information as possible. And we'd always send out emails to the agents or the applicants themselves, just trying to gather as much information from them.
Availability of alternative sites you deal with as well?
I do deal with through my DM, doing plan applications, yes. I'm not aware of any sort of available sites that are within the borough. I've not had any put forward to me dealing with any type of plan application or enforcement case.
So what is happening at the Oak Lane site?
Sorry?
Is it the Oak Lane site?
Oh, there is opposite, there is Oak Lane, which is a gypsy and traveller site. We do have an Essex traveller site in Hoefield as well, but as far as I'm aware, I think that is full capacity as far as I'm aware. But there is an Oak Lane site opposite on the other on the A127. Sorry, it's not opposite, it's is along the A127. I'm not aware of the capacity on that site, but there is Oak Lane. We have actually a few G&T people.
Sorry, I had somebody somewhere there that there was a large number of vacancies on it, but I wasn't sure whether it was,
I'm not sure on that. I don't know.
I understood there was some problems there.
I from dealing with other sites, and I'm aware that there's been some people, some occupiers that have recently vacated that site to move elsewhere on other people in the borough.
I think somebody from here has actually. Somebody on on this site.
There was a mention of someone did move from Oak Lane. I can't remember who that was.
I can't remember where I've seen the mention. Okay. So you can't help on alternative sites. You're not aware of any.
I'm not aware of the capacity on alternative sites, no.
And on the temporary consent issue, if I was to look at a grant of temporary planning permission, what period would be appropriate? What event should I be looking towards?
Generally, it's 5 years that I have seen previously. Alternative consents is kind of standard.
There isn't a standard.
Well, generally you see,
but 5 years does crop up.
Yeah.
You deal with antisocial behaviour.
I've dealt with it in my proof, for this site.
Yeah. How does that fit in?
We've had a lot of
how does it fit in? I mean, in terms of policy wise.
There is no policy here at the council with regards to antisocial behaviour.
Is it something I should be giving weight to in this?
Obviously that's entirely up to you, but there has been a number of incidents that have been brought to our attention. The neighbours actually did raise some yesterday about firearms incidents. There's been a number of fires as well on the site where both police and the fire rescue service has been called out. That's something that you might want to give some consideration to.
No, but you haven't brought it forward into the planning balance. You just mentioned it.
Yeah, this was after I haven't brought it into the planning balance. No, it was these incidents were made. We were made aware of them after the proofs are done and the planning balance.
So just finally then, let's assuming again that Mr. Green is right, and it wasn't didn't have to leap the very special circumstances hurdle. What would be your conclusion on the, if granted that we have to apply substantial harm or substantial weight in any case to greenbelt harms?
So if we were to apply substantial weight to the greenbelt harm, if Mr. Green was right in his, I do consider that its site or as in its current form, is harmful to the greenbelt, significantly harmful to the greenbelt and its openness.
You've referred to saved policy BASBE 12
Mhm.
of the local plan.
Yeah.
You just give me a view on consistency with the NPPF.
So the BE 12 policy is to do with design and character, and it is compliant with the current NPPF as of this year. So yeah, it just sets out sort of the assessment that we need to undertake with regards to sort of the layout, all that kind of stuff. So yeah.
I take it does crop up now and again in appeals that you have to.
Yeah, no, that's one that we use regularly on most appeals. Yeah.
Yeah, so you do get asked this question. I take it
Yeah.
regularly. Okay. I think that's all I've got. Yes, nothing. Thank you, Ms. Ellis. Does that complete your case?
That is the case for the council. So,
Yeah, one thing we haven't discussed, of course, is some conditions.
it might be the statement on ground.
Yeah, thanks.
My point of view,
Yeah, I can see you've still got your, yeah.
I'm.
Yeah, they do have them. It's not that rare in enforcement.
Well, for ops, I suppose, but most of my.
Yeah.
It's almost better than that.
So treating into that statement on ground approach for a moment.
Yeah.
You've got the conditions of the statement on ground.
Yeah.
Moving the statement on, which then is only the ground and appeals which conditions put attention.
I'm just trying to find here. I'll just run through them. Condition one is the occupancy condition, and seems to be you're using the 12 definition there as the basis, I think. That's fine. 2 I can adjust as necessary, but 14 pitches. Is that accurate, Jim? There's 2 and 3. Yeah. So you've got the enforcement style condition covering layout. Buildings and hard standings. Is that you wanted to show existing buildings? Condition 3. 3 Roman numeral 1A. I'm just trying to make sure there's no, we're not talking about any new day rooms or anything. I think we're not. You're talking about what's there already.
What's there already?
Because I'm not being asked.
Yeah.
Well, I can't grant permission for. Yeah. Foul and surface water drainage. I assume that. Can somebody tell me the electricity supply position was that there is an ability to connect to the grid. Yeah, and I take it foul and surface water drainage have, well, I take it the foul anyway has an ability to connect to the local sewage system. It's not what?
I don't think.
Okay, well, it's only to provide the means, but yeah. So essentially, the electricity issue with generators and stuff can be resolved. Yeah, and you've got proposed and existing external lighting. There was a nearby site that had difficulty with drainage at Appeal, I believe. Not ringing their bells. Yes, there was an inquiry last year, I think. Yes, that's I do remember that, and it partly went down on that basis, didn't it? Yeah. There was So you're saying, because obviously there's not really any scope for septic tanks here.
No, there's not. I don't think there. I don't know how it's connected.
Yeah.
Currently. Yeah, that we have. Environmental. On waste entering into building. But I don't know how we.
Okay, anyway, it requires to be specified, obviously. Landscaping, screening details of species, plant sizes, and so on. Number 4, no commercial, industrial, or business activities, including storage of materials. Should be fine. No vehicle over 3.5 tons should be stationed, parked, or stored. Is that, yes, okay, well, 3.5 tons standard transit size truck, isn't it? And then you've removed permitted development rights for buildings, structures, means of enclosure other than those approved. Well, so there's nothing out of the ordinary there, really. So. Yeah, that should be fine. Okay, thank you, Ms. Ellis. Mr. Cummings. Mr. Goodman still typing? All right, I was going to say, did you need a few minutes to? No, okay, you're done. You're done.
I'll just email one.
Okay.
No, I'm not taking part.
Yeah, I was just, sorry, I was staring at my tiny little clock down here. Yeah, so it's, yeah. Okay, well, if it's 20 past now, if we just resume at past, and you may have printed copies by then. Okay, I'll adjourn then until Are we ready to resume? Okay, did you get your closing printed, Mr.?
Start with them.
Yeah. Yeah, I assume there's not going to be any corrections to be made, because I don't have anything. Well, if there is, just say yes. Yeah. Sometimes when you're reading it yourself, you'll spot things that are missed. Yeah. Yeah.
This is the closing statement of Basildon Borough Council. These appeals all concern a site situated on the eastern side of Newlands Road at the end of the unadopted road. The land is designated as green belt in the adopted saved local plan and is the subject of a plotland designation on the saved proposals map. And as Ms. Gruner identified, was specifically considered as part of that. The appeal site is a rectangular piece of land, and I described that. I then described plot 1, accesses onto Newlands Road and is known as the paddocks. It comprises a mobile home, an area of hard standing on the front, an in-out driveway, a small outbuilding, laid lawn at the rear. Ms. Wilkinson, who lives on this plot, did present an appeal on behalf of Mr. and Mrs. Anderson. Ms. Wilkinson told the inquiry she has lived on plot 1 with her 4 children since 2014. The council accepts on the basis of her written evidence and of its own knowledge of the family that Ms. Wilkinson and her family enjoy gypsy traveller status. Plot 3, the plot comprises 2 mobile homes, a stable building and an outbuilding as a shed and kennels. The plot is mostly laid to hard standing with a small area of lawn. Timber fencing and gates demarcates the boundary of the plot. There is an access road that aerial images suggest was laid in 2018. This plot is occupied by Levi Anderson and family, who are represented by Mr. Green, and the council accepts have lived here since at least 2018. Mr. Anderson has provided a witness statement in draft in council's bundle in which he says that he is 38 years old and lives on site with his wife and his wife's parents and his 2 children. Neither child attends school. The 13-year-old is tutored at home twice a week. The council accepts on the basis of his written evidence and its own knowledge that Levi Anderson and his family enjoy gypsy and traveller status. Plots 4 to 14 are owned by the Sharp family. The council does not accept, based on its own knowledge of Mr. Sharp, that he enjoys gypsy or traveller status. There's insufficient evidence before the inquiry to evidence that he does. It appears that the 2010 inspector accepted historic cultural connections of one of the Sharp family to travellers, but there's no evidence otherwise. The council has no knowledge about the occupants of plot 2, who have not responded to attempts to engage with them on site and have not participated in the inquiry process. None of the appeals by any owners or occupiers of the Sharp-owned plots have been pursued beyond the filing of appeal notices. Mrs. Stokes, who came to the inquiry yesterday, said she was the occupier of plot 13. She is not an appellant, did not attempt to make a ground E appeal concerning her claim not to have known about the inquiry. Mrs. Stokes gave a vague explanation as to why she said she did not know about the appeal, saying she was unable to read any of the many notices around the site and had not heard from anybody else about it. However, she had in fact heard about the inquiry, was able to prepare written statements, but gave no explanation as to why that was only able to happen on the day of the inquiry. Her evidence says little that can be given and can be given little weight. Without any concession as to its veracity, taking her evidence at its highest, she had been on site for a year and would have known, not least by the lack of electricity and other utility connections, that the site is not authorised. The evidence of personal circumstances is thin and can be given little weight. I then set out the breach of condition 2 and paragraph 10 I'll take as read as well. Paragraph 11, the council has agreed a statement of common ground with Ms. Wilkinson on behalf of Mr. and Mrs. Anderson on plot 1 and Mr. Green on behalf of Levi Anderson and Basildon Borough Council. In respect of the 22 of April 2022 enforcement notice concerning the breach of condition 2, the parties have in that statement of common ground invited the inspector to vary the notice at paragraph 5 so as to add the words at the beginning of paragraph 5 as follows: with the exception of 1 static caravan and 1 touring caravan on plot 1, and with the exception of 2 static caravans and 1 touring caravan on plot 3. And then it goes on to the wording in the notice. The Appendix 1 notice plan will be amended to mark plots 1 and 3. The effect of this proposal will be to under-enforce, pursuant to section 173(11), such that, combined with the measures below, the enforcement notice will, if upheld, continue to bite across the rest of the site. The operational development enforcement notice concerns the majority but not all of the appeal site. The area of the appeal site with which the operational development notices concerned is shown on the plan attached to the enforcement notice. At paragraph 3, I set out the breach, but for the appeals, it would have required paragraphs 5 and 6. And then at paragraph 15, we explain that in respect of the enforcement notice dated 22nd of April 2022 with the irregular shaped notice plan, in paragraph 5, the intention in the statement of common ground was to invite the inspector to amend the notice so as to add the words at the outset, with the exception of the hard standing form and access way to plot 3 coloured green on the attached plan, and the plot will then be amended to colour green the access road to plot 3. So the plan will then be amended to colour green the access road to plot 3. The effect is to under-enforce against the hard standing and access way connected to plot 3, Levi Anderson and family. And then in respect of the enforcement notice dated 28th of September 2020, the parties to the statement of common ground invite the inspector to allow Levi Anderson's appeal against the enforcement notice on ground A, thereby granting planning permission for the matters alleged, namely the laying of hardcore and hard standing related to plot 3. The council will write a letter of comfort to Levi Anderson stating that it will not take any enforcement action in respect of any use of him of plot 3 for the stationing of a commercial vehicle in addition to a commercial vehicle on plot 1, and ask the inspector to mention that in this decision letter. If you accept the invitation we propose. Here the argument would be that in light of the choice to under-enforce on the other notices, there are very, very special circumstances which allow for this appeal to be allowed. The council considered withdrawing the notice but decided it's preferable to accede to the appellant's request to allow greater certainty as to the grant of permission for this hard standing. If but only if the inspector is minded to determine the appeals on the basis proposed here, Mr. Levi Anderson will withdraw his other appeals and Miss Wilkinson will withdraw her other appeals. If the inspector is minded to accept this invitation, the council would invite the inspector to dismiss all of the other appeals. I turn to address those. The ground A appeals. Mr. Levi Anderson is the only appellant to have pursued a case on ground A with evidence, but a number of the other appeals also raise ground A. The determination of the ground A appeal will need to be made in accordance with the development plan unless material considerations indicate otherwise. The council adopted the Basildon district plan, and I then set out the policies which I've addressed in opening through already, so I won't repeat them through to paragraph 25, and then picking up again from paragraph 26. For the council, Ms. Ellis gives evidence that the development of the site amounts to inappropriate development in the greenbelt, and substantial weight should be given to the harm by way of inappropriateness. In her opinion, the development causes significant harm to openness and conflicts with the purposes of including land in the greenbelt. Ms. Gruner explains that the development harms 4 of the 5 purposes of the greenbelt and amounts to sprawl and encroachment. Mr. Green makes a clever argument about inappropriate development, but it is wrong as a matter of law and as a matter of interpretation of the NPPF. His argument is that because the enforcement notice relates to a breach of condition, there is no development at issue in the enforcement notice. Mr. Green's argument confuses the mechanism, the breach of condition notice, with the purpose of the mechanism to secure the proper planning of the area in accordance with the development plan and other material considerations. Section 172(1) of the Town and Country Planning Act 1990 provides that the council may issue an enforcement notice where A, there has been a breach of planning control, and B, it is expedient to issue the notice having regard to the provisions of the development plan and to any other material considerations. Section 38(6) of the Planning and Compulsory Purchase Act 2004 provides that if regard is to be had to the development plan for the purposes of any determination under the Planning Acts, the decision must be made in accordance with it unless material considerations indicate otherwise. Consequently, the council and the inspector would be acting unlawfully if they failed to have regard to the development plan and any material considerations in issuing the enforcement notice or in determining the appeal against it. Development plan, Greenbelt policy and paragraph 147 of the NPPF are therefore a material consideration to a determination of an enforcement notice. The duty to determine in accordance with the development plan is not evaded by the mechanism being a breach of condition. That is illustrated most straightforwardly here because there has been considerable unauthorised operational development. That unauthorised operational development is development. The mechanism for controlling it is the breach of condition notice. The effect of the notice will be to restrain that unauthorised development. Mr. Green's argument is notable that there is no authority, in that there is no authority cited to support it, despite the wide implications it would have for enforcement on breach of conditions in any context. The question of whether there has also been a material change of use therefore does not need to be addressed. it's enough to illustrate that Mr. Green's argument is legally unsound to show that operational development can be controlled by a breach of condition notice. The council has not taken a view one way or another on that issue in issuing the breach of condition notice. It did not need to. However, it's not accepted that what has occurred on site is merely intensification of the permitted use as a gypsy or traveller site, and therefore not a material change of use. The evidence available indicates that much of the site is not a gypsy or traveller site, some of it simply low quality housing. The site is also used for waste disposal operations. While no position is advanced on this, it would, if the matter had to be considered, be open to the council to treat the site as having involved a material change of use, in that there is a mixed use on site. This is not a case being advanced. It is to illustrate the flaw in the argument for Mr. Green that policy concerned with inappropriate development can never be considered as relevant where the enforcement mechanism is a breach of enforcement notice. Sorry, is a breach of condition. The council submits there is also significant other harm set out in both the evidence of Ms. Ellis and in the landscape proof of evidence of Silke Brunner. That evidence concludes that the development results in substantial harm to the landscape character of the appeal site. This harm will be in conflict with policy BAS BE 12 of the local plan and paragraphs 130 and 174 of the MPPF. It is relevant to have regard to the cumulative impact of the development and of the appeals, notwithstanding that the appeals are focused plot by plot. The council submits that the cumulative impact exacerbates the harm to the greenbelt. The development results in development contrary to 4 of the 5 purposes of the greenbelt: a loss of openness, failure to check unrestricted sprawl of built-up areas. Here, Ms. Gruner explained the sprawl of Wickford. It is effectively an addition to existing sprawl, she explained. A failure to prevent towns merging into one another, an encroachment to the open countryside, and the development of greenfield land. The 2 key built-up areas are Wickford and Basildon, and this part plays an important role in containing these settlements and their boundaries. Ms. Gruner described the fragility as having been constituted in the particular character of that bit of greenbelt, which is already quite built up. The more development intensifies, the less this part of greenbelt performs its function. It is clinging on to its function already. The fact it is already heavily developed reinforces the importance of the green fingers. On encroachment, the site has permission as a caravan site, but with limited built form. It is not a settlement. The remainder of the field was probably a paddock previously, but for the recent development have been perceived as countryside with development on it. Ms. Gruner's view, expressed in all evidence, is that there is still harm to the greenbelt countryside, and that will be will be less landscape harm, less greenbelt harm as a result of the statement of common ground approach than there is currently. It leaves more open areas. It will be closer to the development of the closer to the character of the development in the vicinity of the area. The statement of common ground approach allows for permanent plots more in keeping with the character of the wider area, and a density more in keeping with the character of the surrounding development than the existing situation. The retention of lower density through the statement of common ground approach avoids the greater harm from glimpse views that eventuates from the density of current development. Condition 2, the council submits the condition 2 that the permission is both reasonable and necessary. And then I've reiterated what we said about the inspector in 2010. Very special circumstances from paragraph 40. The inspector will need to consider whether harm by inappropriateness and other harm is outweighed. For Levi Anderson, he relies on a case around need. Mr. Anderson's case disputes the development is inappropriate at 41. This argument is made on the premise that there's been no development of the land. That's a misconceived legal point, as I've now addressed. Paragraph 42, Mr. Anderson relies on material considerations as amounting to very special circumstances. In summary, these are need, etc. The council does not accept that its published Gypsy Traveller and Travelling to Show People Accommodation assessment is inaccurate or otherwise underestimates need in its area, whether on a Lisa Smith approach or a PPTS definition. The council accepts it does not have a 5-year supply of Gypsy and Traveller pitches as at today's date, as set out in Table 5 at paragraph 5.1 of the proof of Ms. Pilgrim adopted by Ms. Lyons, as was discussed in the round table. The council accepts there is an unmet need of 25 pitches over the 5-year period, and notes likewise there is a lack of local housing supply more generally. As Mr. Jarman explained, his assessment work in 2017 and the update in 2019 to 2020, taking account of new survey work and the modelled population uplift, all of that work had preempted the Lisa Smith approach to definition. Mr. Jarman explained his methodology for survey work, which was robust. The council has tried and been willing as a Greenbelt authority, as explained by Ms. Lyons and its approach to this appeal. The pitches on plots 1 and 3 which are accommodated in the survey work, were part of the survey work being undertaken in 2017 and 2019-2020. The council's current development plan has no development management policies relevant to, but the draft plan next year, while at a very early stage, is likely to look at a mix of allocation and development planning management policies. The council may isolate some sites for gypsies and travellers, as has been the approach in London Borough of Havering. The draft local plan will be going out at the end of next year with adoption in 2027. That has been slowed down by the NPPF. The Regulation 18 draft plan might be delayed by the NPPF, but at the most by 1 quarter, and the aim is to have a draft plan by the end of next year. Mr. Jarman explained that the enforcement of breach of condition on gypsy and traveller sites by non-travellers is a realistic option to free up considerable supply. And as Ms. Lyons explained, survey work connected to that process has been undertaken. Mr. Jarman's latest unpublished survey work suggests there is, in addition, additional non-traveller accommodation beyond the aerial survey work. The census evidence, as set out in the evidence, shows a drop in gypsy and traveller population in taking account of Roma, and that is in spite of what Mr. Jarman described as considerable efforts to improve methodology. Mr. Green's observation that he would be in agreement with 90 to 95% of what Mr. Jarman said is testament to the fairness and independence of the evidence presented to the inquiry in the round table by the council's witnesses in the context of this inquisitorial format. The council does not accept there has been a failure of policy. In taking the view that there are sound planning grounds for allowing the development of plots 1, the plot developed at the time of the 2010 appeal, and plot 3, the council's position echoes the conclusions of the 2010 inspector. He considered that in the context of development on a scale greater than he was considering, the narrow strip of greenbelt in which the site sits is particularly fragile and vulnerable. He considered that the modest development he was considering was inappropriate development, which failed to secure the purposes of the greenbelt, encroachment, merger, and loss of openness, and caused other harm to the appearance of the area. The inspector in 2010 was persuaded, however, that a limited encroachment to the countryside and limited greenbelt harm of no more than 2 caravans could be justified, given the limited nature of the harm and the very special circumstances arising largely from the need for gypsy and traveller sites at the time. The council, in the position taken in the Statement of Common Ground, extends the planning balance struck by the inspector in 2010 to the provision of an additional plot for a gypsy and traveller family with 2 children and elderly parents that has long been on the site. While the council's view is that the additional plot will be harmful to the openness of the countryside and harmful to the green belt for the reasons set out already, the harm of one additional plot is much more limited than the development of the whole site, which is currently the reality at the site and represents a similarly limited degree of encroachment of a kind alike, albeit more extensive to that considered by the inspector in 2010. While allowing a further plot over and above that which the 2010 inspector allowed will encroach further into the open countryside and will further harm the green belt and its purposes, the council considers the limited additional harm is capable of being regarded as outweighed by a number of factors. In summary, the retention and development of plot 3 in the way proposed by the Statement of Common Ground, the enforcement notice will operate to some, albeit a more limited extent, than enforcement across the whole site to preserve openness and restrict encroachment into the open countryside and protect the purposes of the green belt. It will require the restoration of the large majority of the site. In the long run, it will provide a basis, if required, for a pragmatic and realistic set of next steps around enforcement, which can ensure the restoration of other plots to their original condition. The council takes the view that allowing an additional plot is at this point the proportionate balance between the planning objectives for openness and greenbelt and public amenity on the one hand, against its acknowledged lack of a 5-year supply of sites and personal circumstances in plots 1 and 3 on the other. As Ms. Ellis confirmed, in light of all the evidence that has been available as a result of her visits to the site in August and November, and in the course of the appeal process, there are no sufficiently evidenced compelling circumstances related to occupiers of other plots. The council does not consider that allowing the whole site to become a mix of gypsy and traveller site with a transit site for all comers has achieved that balance. By contrast, the limited additional encroachment beyond the 2010 position can still do so. In fact, the council, taking a pragmatic approach, considers that in the real world, an enforcement notice which under-enforces against plots 1 and 3, in fact, has a stronger chance of leading to effective action securing restoration of the site, because the council considers it's likely, given the history of the site, that there may be further non-compliance with the enforcement notice. There will be further legal action, whether by prosecutions, injunctions, or direct action to install restoration. In that process, the personal circumstances of Miss Wilkinson and her family, and Levi Anderson and his family, including the interests of their children who are also settled there, will be relevant, and considerations of proportionality will all become relevant. When taking that longer view, the council considers that having carefully balanced all of the planning factors as well as personal circumstances at this juncture, it will be in a stronger position to take further enforcement action in what seems to the council to be the likely event of further non-compliance with the enforcement notices after the expiry of the period for compliance. I then deal with conservation of habitats and species regulations. Natural England has identified that new residential development within the zone of influence is likely to have a significant effect on the features of interest of special protection areas and Ramsar sites through increased recreational pressure. The aim of the RAMS work is to secure financial contributions or other forms of on-site mitigation known as SAM from developers to deliver projects that would mitigate the likely impact of development. It's been confirmed that Mr. Anderson has attempted to make a contribution designed to reflect the impact of the development of 2 static caravans on his plot. While that would not mitigate the development of the whole site, it is capable of mitigating the development of his occupation of plot 3. Plot 1 may, taking a broad view for these purposes, be regarded as equivalent to the established development in 2010, which had already, prior to the Natural England guidance, allowed it for a static caravan on the site. And so no additional contribution is required in respect of that development, since there is no new occupation or recreational pressure to be mitigated. The position proposed through the statement of common ground would therefore, if accepted by the inspector, achieve certainty that the pressures on the habitat site created by the additional development have been mitigated by Mr. Anderson's contribution. The council would, however, maintain that no additional residential development can be allowed in this appeal on the habitats basis, since there have been no contributions paid or offered in respect of any other residential development. Consequently, the inspector would be unable to rule out the possibility of adverse effects from the additional residential development on the habitat site. There are, for the avoidance of doubt, no circumstances of overriding public interest that might justify development without mitigating such impacts. Conclusion on the merits: the council submits that the development of the site is in conflict. So beyond plots 1 and 3 is in conflict with policy BAS GB1 of the district local plan, the MPPF in particular paragraphs 138 and 147 to 50, and so far as it is engaged the PPTS, in particular policy E. The council adopts the same position whether or not the caravans are stationed on a temporary or permanent basis. While the development of plots 1 and 3 is considered to be harmful for the reasons set out above, that harm is outweighed in the event of the limited development of plots 1 and 3 and the restoration of the remainder of the site. Ground D. In Levi Anderson's appeal, it's agreed that the entire appeal site is to be considered when assessing breach of conditions. That chimes with the previous inspector. The various appeals for Mr. Anderson raising complex legal arguments are proposed to be withdrawn and are not addressed further at this stage. The council, however, for the avoidance of doubt, maintains its position as set out in opening, that there's no proper legal basis for them and that they have proceeded on erroneous factual premises. Ground F, the appellants have argued under F that the requirement that all caravans, save 2 allowed in compliance with condition 2, be removed is unenforceable. There are a number of variants of this argument made that because the land has been recently sold or leased into parcels, there is now a fait accompli, which in effect trumps planning control over the unit as a whole. There is nothing unenforceable about condition 2 of the 2010 permission, which was imposed by the Secretary of State after careful consideration by an inspector. It remains enforceable in the event of the under-enforcement proposed in the statement of common ground. Ground G, assuming Mr. Anderson no longer appeals on ground G, that leaves the remaining appellants who have not participated. They've each been given ample notice and de facto lengthy extensions of occupation. Many, as detailed in opening, appear to have never been on site, to have left the site, or to have arrived only recently. A full evidential picture is not being provided by the appellants. The period for compliance is in the circumstances entirely appropriate. The other Levi Anderson appeals are to be withdrawn in the event of the statement of common ground. I've set those out at 61 to 63. And then dealing with Ms. Wilkinson, again, she proposes to withdraw her appeals in the event of the statement of common ground invitation being accepted. However, the council submits otherwise that on ground B, her appeal should be dismissed. The 2010 permission concerns the appeal site in its entirety. The conditions on the 2010 permission apply to the entirety of the appeal site, and it's apparent that the matters stated in the first enforcement notice occurred because on the appeal site there are more than 2 caravans. Ground C is only pursued by Mr. and Mrs. Anderson, represented by Mrs. Wilkinson. There's also a ground D appeal. None of Ms. Wilkinson's grounds of appeal can succeed. She has not relied on grounds A or G. Her case is essentially that she should be regarded as the original occupier of the site with the personal benefit of the 2010 Planning Permission. The Planning Permission is a legal document to be construed objectively. It allows no more than 2 caravans on the 2010 site as a whole. It did not specify that Ms. Wilkinson's site was distinct. It is apparent from the various conveyances that in selling off the various parcels of land, there have been involvement of solicitors alive to the need for covenants. Covenants have not been imposed on each of the disposals. So covenants have been imposed in each of the disposals, but no covenants sought to secure to Miss Wilkinson that her site would be the only one with the benefit of planning permission. Miss Wilkinson and her family are recognised as being gypsies or travellers and have been on site for almost 10 years, and there are personal circumstances that attract weight. The council is conscious that in her mind and in that of Mr. Anderson, she is the beneficiary of the planning permission from 2010, and that she and her family moved to the site with that understanding in 2014, and for several years that was reflected in the reality on site. She is understood to have legitimate connections to utilities and to have paid council tax. While on a legal analysis, Miss Wilkinson's occupation is part of and not distinct from the much wider breach of planning control, through a human rights lens, her position is different from the other occupiers. Accordingly, although she did not raise a ground G or ground A appeal to which those considerations are relevant, and although she consequently has not sought to support her human rights issues with evidence or to plead a case on that front, those matters will fall to be considered, if not in these appeals, in any subsequent enforcement processes. As set out above, therefore, the council, in proposing the approach in the statement of common ground, while acknowledging the planning harm that the approach will cause, is mindful of countervailing factors arising from the lack of a 5-year supply and from the personal circumstances of Ms. Wilkinson, and is realistically conscious that future enforcement action will in any event need to take into account those factors, even if not raised in her appeal. The statement of common ground approach has sought to bear those factors in mind more broadly as material to the overall balance which is struck by the approach advanced to the inspector therein. So that then leaves the remaining appellants who have not participated further, and I've set out our understanding of who those are. In particular, we understand the Sharp family owns plots 4 to 14. See the land register copy entries in the appendices to the proof of evidence of Mr. Cummings. The following advanced no proof of evidence, have not participated in personal inquiry and have not communicated in any way, and I set out which appellants those are. The council believes also that some appellants may never have lived on the site, and that Ms. Connors, who we heard evidence about today having 4 children in local schools, has left the site and no longer lives there. The council's had no further communication since the appeal notices. Paragraph 73, the council submits that very low weight can be given to the personal circumstances of the occupiers, including the Stokes family, of plots 2 and 4 to 14 in these circumstances. Mr. Cummings, as explained in evidence, has been on site on numerous occasions, has engaged as far as he can with residents on site, in person, through correspondence and with agents. Neither from the occupants themselves nor from these investigations have any cases of compelling personal circumstances arisen. Mr. Cummings described the situation as a whole as discordant, with some non-travellers. There do not seem to be strong family links as between the occupants over the site. It's far from a cohesive or stable site in that respect. Similarly, very low weight can be given to the asserted need, insofar as it might relate to the development of any of these plots. There is no basis on which any of these appeals might be permitted, given that nothing has been offered in evidence. There is no evidence on mitigation or proposal to mitigate or landscape, etc., which might make the proposals even remotely acceptable. There are not even at a very basic level contributions to mitigate habitat harms. The development of plots 2 and 4 to 14 is particularly harmful in that it cumulatively encompasses the whole site without minimising the encroachment on open countryside at all, encompasses significant landscape harm, is inappropriate development, and offends all of the purposes of the Greenbelt. The development is particularly unsightly and unregulated, has been the cause of significant impact on amenity of local residents. There are no countervailing circumstances outweighing all of that substantial harm. Dismissal of all of these appeals is therefore inevitable and unavoidable. The inspector is invited to dismiss all of the appeals with the exception of Levi Anderson's appeal seeking to retain hard standing and access to Block 3. The inspector is invited to amend the enforcement notices in line with the proposals advanced through the statement of common ground, in which event the active appellants have proposed to withdraw all of their other appeals. Very quickly, sir.
Thank you very much, Mr. Goodman. Site visit arrangements. First, who's going? Are you still going to site? Okay. You'll be there, obviously. And yourself, two of you from the council. Yeah. Yep, I'll be back. So let's see. Mr. Cummings. Yeah. 1 o'clock. 2:15. That sound reasonable? Yeah, and obviously we'll need to see the Chase side as well, and they're not connected, so I can do the Chase myself. Obviously,
Yes, I see.
it's probably simpler. Yeah, I can do. Parking. Is it possible to park at your plot? It's been the first one in, isn't it? Yeah. Okay. And are you all traveling in one car?
Yes.
Yeah. Okay. Just so that you can you know who to expect. One car at the council.
Unmade pothole road.
Yeah.
It's been tarmac now.
Oh.
We are better road.
Good. So we can park it at yours at 2:15, and you'd expect myself, one council car, Mr. Green, some massive Volvo, whatever it is. That's good. Okay, thanks very much. Thanks everybody for a very cooperative inquiry. What could have been quite difficult. I'd like to thank Ms. Wilkinson or congratulate her for her advocacy, which is very well done, given it's a completely unfamiliar world for you, I'm sure. And yeah, thanks to all the council for looking after me, looking after everybody else. And so I'll formally close the inquiry if there's nothing else. Thank you very much, everyone. Thank you.